Over 60% of small California landlords say new regulations are cutting directly into their profits, and 2026 could be even worse. What if I told you that a single overlooked rule could cost you thousands of dollars, trigger lawsuits, or even freeze your ability to raise rent? Most property owners think they're protected, until a notice arrives in the mail or a tenant quotes a law they've never even heard of. Here's the reality. 10 new California landlord laws have just passed, and they are quietly reshaping everything, from rent increases and evictions to security deposits and mandatory payments. These aren't small tweaks. Some of these changes can completely alter your cash flow, increase your liability, and turn what looked like a stable investment into a legal minefield. The scary part? Many landlords won't realize the impact until it's too late. In this video, we're breaking down exactly what changed, what it means for your property, and how you can protect your investment before 2026 hits hard. Stay with me, because one of these laws might directly affect you. Number 1. Stricter rent caps. California has tightened the rules on how much landlords can raise rent in 2026, and this change is bigger than many investors realize. Under updated statewide limits, annual rent increases are now more closely controlled, especially in properties covered by existing rent stabilization laws. While this may sound like a minor adjustment, even a small percentage difference can dramatically reduce your long-term cash flow, especially if inflation, insurance, and maintenance costs continue rising faster than the allowed rent increase. Many landlords are discovering that their expenses are climbing, but their ability to adjust rent is now restricted. What makes this even more serious is that some local cities are adding their own layers of regulation on top of state rules. That means you could legally raise rent one amount under state law, but be limited to an even lower cap under local ordinances. If you miscalculate, you risk penalties, tenant disputes, or forced refunds. In other words, one incorrect notice could cost you thousands. To protect yourself, review whether your property falls under statewide caps, local rent control, or exemptions. Recalculate your 2026 projections based on realistic allowed increases, not hopeful ones. Smart investors are already adjusting strategies, renegotiating expenses, and building stronger reserve funds before these caps squeeze margins even tighter. Which of these new laws worries you the most as a landlord? Comment below. We read every single one because we put serious effort into bringing you real, research-based updates. And if this helps you even a little, hit subscribe. It's just one click, but it helps us keep protecting landlords like you. Number 2. Just Cause expansion. One of the most serious changes for 2026 is the expansion of just cause eviction protections. This means landlords can no longer simply choose not to renew a lease without a legally valid reason in many covered properties. The law now clearly defines what counts as at-fault and no-fault evictions, and if you make a mistake in classification, you could face penalties, delays, or even lawsuits. What used to be a straightforward lease decision is now a tightly regulated legal process. Under the expanded rules, tenants who have lived in a property for a specific period gain additional protections. In some cases, even after a lease expires, you must provide a legally recognized reason to terminate tenancy. And the paperwork must be precise. A missing detail, incorrect notice period, or improper documentation can reset the entire process. That means lost time, lost rent, and rising legal costs. For landlords who rely on flexibility to manage underperforming tenants or reposition properties, this change can feel like losing control of your own asset. To protect yourself, review every lease renewal carefully and document everything. Keep detailed communication records, payment histories, and maintenance logs. Before issuing any notice in 2026, consider consulting a qualified landlord-tenant attorney. In today's environment, preparation isn't optional, it's protection. Have you ever dealt with a difficult eviction situation? Share your experience below. Your story could help another landlord. And if you value clear, powerful updates like this, make sure you subscribe right now. One click supports the work we do to keep you informed and protected. Number 3. Relocation payments surge. Another major shift in 2026 is the increase and expansion of mandatory relocation assistance. If you issue a qualifying no-fault eviction, such as moving into the unit yourself, major renovations, or removing the property from the rental market, you may now be required to pay tenants significantly higher relocation fees. And we're not talking about a few $100s. In some cases, this can equal one or even multiple months of rent, depending on local rules. Here's where it becomes dangerous for investors. Many landlords don't budget for this. They assume if they legally own the property, they can simply take it back when needed. But under updated protections, triggering certain types of eviction automatically activates a financial obligation. That means if you plan to renovate, sell, or reposition the property in 2026, you could be forced to pay thousands before you even begin. Even more concerning, some cities add extra relocation protections for seniors, disabled tenants, or long-term occupants. That can multiply costs further. A project that looked profitable on paper can suddenly shrink once relocation payments are factored in. Smart landlords are now building relocation reserves into their financial planning. Before making major decisions, calculate worst-case payout scenarios. Review your local city rules carefully, not just state law. In 2026, strategic planning isn't just smart, it's survival. Did you know about these relocation payment rules before today? Be honest in the comments, and if you appreciate this kind of detailed breakdown, hit subscribe now. One simple click helps us continue delivering powerful updates that protect your investment. Number 4. Deposit limits reduced. One of the most underestimated changes in 2026 is the new limit on security deposits. California has moved toward stricter caps, meaning many landlords can now collect only 1 month's rent as a deposit for most residential properties. That may not sound dramatic at first, until you think about the real-world risk. For years, security deposits acted as a financial cushion. They protected landlords against property damage, unpaid rent, and cleaning costs after move-out. But with reduced limits, that cushion is thinner than ever. If a tenant causes serious damage that exceeds the deposit amount, you're left chasing the balance through small claims court, and there's no guarantee you'll recover it. That shifts more financial risk directly onto you. This change also makes tenant screening more critical than ever. Since you can't rely on a larger upfront deposit for protection, your first line of defense becomes careful background checks, income verification, and rental history reviews, all done within legal limits. Preventing a bad tenancy is now far more important than trying to fix one later. To stay protected in 2026, consider requiring renters insurance, conducting thorough move-in inspections with documented photos, and creating detailed condition reports signed by tenants. With tighter deposit caps, preparation isn't optional, it's your new safety net. Do you think 1 month's deposit is enough protection in today's market? Drop your opinion in the comments. We want to hear from real landlords. And if you value serious, no-fluff updates like this, make sure you subscribe. One click helps us keep fighting for your financial awareness. Number 5. Repair deadlines tightened. In 2026, California is getting tougher on habitability and repair timelines, and this change could quietly cost landlords more than they expect. Under updated enforcement standards, once a tenant reports a serious issue, like plumbing failures, heating problems, mold concerns, or electrical hazards, you may now face stricter deadlines to fix it. Delays can open the door to rent withholding, fines, inspections, or even lawsuits. The key issue isn't just the repair itself, it's documentation and response speed. If a tenant claims you ignored a maintenance request, the burden often falls on you to prove otherwise. And in some cities, enforcement agencies are becoming more aggressive about habitability complaints. What used to be handled informally between landlord and tenant is now increasingly regulated. This means waiting a few extra days to schedule a contractor could turn into a legal problem. If a repair qualifies as urgent, the expectation is fast action. And if you fail to respond properly, tenants may gain leverage, including the right to make repairs themselves and deduct from rent under certain conditions. To stay ahead in 2026, create a written maintenance protocol. Respond to all requests in writing, keep time-stamped records, and build relationships with reliable contractors before emergencies happen. Preventive inspections twice a year can also reduce surprise issues. In this environment, maintenance isn't just upkeep, it's legal protection. Have you ever faced a repair dispute with a tenant? Share what happened below. Your experience might help someone avoid a costly mistake. And if this breakdown is helping you stay prepared, don't forget to subscribe. One click keeps you informed and ahead of the changes. Number 6. Screening rules restricted. California is also tightening the rules around tenant screening, and this one could dramatically change how you evaluate risk in 2026. New restrictions limit how landlords can use background checks, credit reports, and prior eviction history when deciding whether to approve an applicant. The goal is to increase housing access, but for landlords, it means less flexibility in filtering potential risk. In some cases, certain eviction records may be sealed or restricted from consideration. There are also stricter guidelines on how application fees are handled and how quickly screening decisions must be processed. If you deny an applicant, you may be required to provide specific written reasons that comply with fair housing standards. One poorly worded explanation could expose you to discrimination claims, even if your decision was financially based. This shift means your old screening checklist may no longer be compliant, and relying on outdated criteria could lead to penalties or lawsuits. At the same time, with security deposit limits reduced and eviction protections expanded, the margin for error is shrinking. To protect your investment, review your screening process with a legal professional. Use updated, compliant rental applications. Focus on consistent income verification, rental references, and documented criteria applied equally to every applicant. In 2026, smart screening isn't about being strict, it's about being legally precise. Are these new screening limits fair, or do they increase landlord risk? Let me know your honest opinion in the comments. And if you want to stay ahead of every rule change coming in 2026, hit subscribe right now. One click helps us continue delivering the updates landlords truly need. Number 7. Eviction records sealed. This next change could quietly reshape how landlords assess risk in 2026. California is expanding rules around sealed eviction records, meaning certain past eviction cases may no longer appear in standard screening reports. In simple terms, a tenant who was previously evicted might legally appear as if nothing happened, at least on paper. For landlords, this creates a serious blind spot. Screening used to rely heavily on eviction history as a warning sign. But under updated protections, some records may be automatically sealed if the tenant wins the case, if the case is withdrawn, or even under certain time conditions. That means you may not have access to the full picture when reviewing an applicant's rental past. The risk here isn't about assuming tenants are bad, it's about losing data that once helped you make informed decisions. Combined with stricter screening limitations and lower security deposits, the margin for protecting yourself is getting thinner. If you approve the wrong applicant, removing them later under expanded, just cause rules becomes far more complicated and expensive. To adapt, landlords should strengthen reference checks, verify employment directly, and conduct detailed landlord-to-landlord conversations whenever legally allowed. Ask better questions. Document everything. In 2026, protecting your property will rely more on due diligence than ever before. Do you think sealing eviction records protects tenants or puts landlords at risk? Share your view below. And if you appreciate this honest, in-depth breakdown, make sure you subscribe. One click helps us continue bringing you the updates that matter most. Number 8. Energy upgrade mandates. Another major pressure point in 2026 comes from expanding energy efficiency and environmental compliance requirements. California continues pushing aggressive climate policies, and landlords are increasingly responsible for meeting new retrofit, insulation, appliance, and emission standards. While these rules are framed as environmentally necessary, the financial burden often lands directly on property owners. Depending on your property type and location, you may be required to upgrade older HVAC systems, improve insulation, replace outdated water heaters, or comply with new local building performance standards. These aren't cosmetic improvements. They can cost thousands or even tens of thousands of dollars. And in some cases, you can't simply pass those costs onto tenants due to existing rent caps. The real challenge is timing. Many of these mandates come with compliance deadlines. Miss the deadline, and you could face penalties or restrictions. That means landlords must plan capital expenditures earlier than expected. A property that once generated steady cash flow could suddenly require a large reinvestment just to remain legally rentable. To stay ahead, review your building's energy profile now. Research local incentive programs, rebates, or tax credits that may offset upgrade costs. Spread improvements out over time instead of waiting until the deadline forces emergency spending. In 2026, energy compliance isn't optional. It's part of protecting your long-term asset value. Are you financially prepared for mandatory upgrades like these? Comment below and let's talk strategy. And if you want to stay ahead of every costly change coming in 2026, hit subscribe. One click helps us keep delivering the insights landlords can't afford to miss. Number 9. Short-term rental limits. If you were relying on platforms like Airbnb to boost your returns, 2026 may bring a harsh reality. California cities are continuing to tighten short-term rental restrictions, and in some areas, permits are becoming harder to obtain, more expensive to maintain, or capped altogether. What once looked like a flexible income strategy is now heavily regulated. Many local governments are limiting the number of days a property can be rented short-term each year. Others require the unit to be a primary residence, eliminating the ability to operate full-time investment properties as vacation rentals. Violations can trigger steep fines, license revocation, or forced shutdowns. And because these rules are often enforced at the city level, they vary widely, making it easy to accidentally fall out of compliance. For investors who purchase properties specifically for short-term income, this shift can dramatically alter projected returns. A property that once generated premium nightly rates may now need to convert to long-term leasing, where rent caps and tenant protections apply. That's a double squeeze on profitability. To protect yourself, confirm your city's current permit requirements and renewal deadlines. Calculate your investment returns under a long-term rental model as a backup scenario. Diversifying your strategy now can prevent panicked decisions later. In 2026, flexibility and compliance will matter more than ever. Are short-term rental rules hurting your strategy? Share your city and experience below. Let's compare notes. And if you value honest, research-driven updates like this, hit subscribe now. One click helps us keep delivering critical insights for landlords. Number 10. Insurance and liability pressure. The final change isn't just about regulation, it's about rising insurance requirements and liability exposure. In 2026, many California landlords are facing stricter underwriting standards, higher premiums, and in some cases, reduced coverage options. Insurance companies are adjusting policies due to wildfire risk, climate exposure, and growing legal claims tied to tenant protections. What does this mean for you? First, premiums are increasing sharply in certain regions. Second, some insurers are requiring property upgrades, like roof replacements, fire hardening improvements, or plumbing updates, before renewing coverage. Without adequate insurance, your property may not even qualify for certain mortgage terms. And if you're underinsured, one major claim could wipe out years of profit. At the same time, expanded tenant protections increase the likelihood of disputes. If a tenant claims habitability issues, discrimination, or wrongful eviction, legal defense costs alone can be enormous, even if you ultimately win. The financial risk landscape is shifting. To stay protected, review your current policy limits, deductibles, and exclusions. Shop around early before renewal dates. Consider umbrella liability coverage for additional protection. In 2026, strong insurance coverage isn't optional. It's your last line of defense when regulations and risks collide. Have your insurance costs gone up recently? Tell us what you're seeing in your area. And if this series has helped you see the bigger picture, don't forget to subscribe. One click helps us continue delivering the updates that protect your investment future. California's rental market is entering a new era, and whether you like it or not, 2026 is a turning point for landlords. When you look at these 10 new laws together, a clear pattern emerges. Tighter rent control, stronger tenant protections, stricter screening limits, higher compliance costs, and rising liability exposure. Each rule alone may seem manageable, but combined, they fundamentally change the risk, cash flow, and flexibility that many investors once relied on. This doesn't mean real estate is dead. It means the strategy must evolve. The landlords who succeed in 2026 won't be the ones who panic. They'll be the ones who prepare. They'll run new cash flow projections under rent caps. They'll budget for relocation payments and energy upgrades. They'll strengthen documentation, screening precision, and insurance coverage. In short, they'll operate like professionals in a more regulated environment. The biggest mistake you can make right now is assuming these changes won't affect you. Even if your property is currently exempt from certain rules, local ordinances can shift quickly. California has a history of expanding housing regulations over time, not reducing them. Staying informed is no longer optional. It's part of protecting your investment. So here's the real question. Will you adapt early or react late? The difference could mean thousands of dollars in preserved profit, or thousands lost to penalties, disputes, and missed planning. Knowledge is your strongest asset in 2026. And the more proactive you are today, the more secure your investment will be tomorrow.